Legislative priority. We've got to establish a policy in Washington labor and industries cases whereby defense-interested attorneys are not allowed to approach, badger, otherwise coerce injured workers, doctors, into obtaining or providing, rather, statements of material misrepresentation unless or until the injured worker is present or given an opportunity that is fair to the injured worker to respond to any allegations that are being made by the defense attorney. Unless we do that, what we really have is a system in which a person is guilty until proven innocent. And we see it all the time in Washington at this point. And so I'll give you an example of the scenarios that we see that happen, and I'll explain how it arises. So, for example, in this scenario, the self-insured employer goes out and conducts a little bit of video surveillance and finds that an injured worker can still mow their own lawn. Can you imagine mow their own lawn? And so the self-insured employers their attorney goes into the attending physician and they make an appointment. The doctor doesn't even really know why the appointment is scheduled, and in walks a small cadre of defense-interested individuals, attorneys, maybe multiple attorneys, investigators, maybe multiple investigators. They crowd the room, they make it hot and stuffy in there, and they take the doctor and they say, "Doctor, I'm an attorney, I'm an officer of the court. I'm here with all these investigators, and we've got some video that we'd like you to see in one of your patients' cases. Doctor, will you look at the video? Because we're relatively certain that you aren't in cahoots with the injured worker. We're relatively certain that you're not in a conspiracy to commit fraud, to fraudulently steal workers' compensation benefits. Doctor, will you look at the video?" And the doctor says, yeah, of course I'm not in a conspiracy to commit fraud or to steal from the workers' compensation system. "Doctor, look at the video. Isn't that your patient?" Yes, it's my patient." "Doctor, he's mowing the lawn, isn't he?" It appears that he is, yes." "Doctor, did he ever once tell you while you were providing care to him that he could mow his own lawn, doctor? Doctor, I need your answer." Well, honestly, my appointments were maybe 15 minutes each, and we discussed things like, how he was having pain that would run down his leg, how he was having difficulty interacting with his wife, how he was feeling depressed because of all the pain, and how he was very much limited. And based on my physical exam findings, I honestly thought he was in need of a decompression surgery in his lumbar spine. "Doctor, did he tell you that he could mow his lawn, doctor?" Well, honestly, I don't think I ever asked him how long his grass was. "Doctor, are you committing fraud with your patient?" Of course I'm not. "Doctor, did your patient tell you, or did your patient not?" Well, no, I guess honestly he didn't. "Great, doctor. Then I prepared a form right here that says that what you've seen in the video is something he didn't tell you he could do. Doctor, will you sign the form?" Well, listen, I don't want to be a part of this. I don't want to be part of any of this conflict, so I'll sign the form. "Okay, thank you, doctor." The defense interest attorneys then go and obtain an order from the Department of Labor and Industries. This says the injured worker has to pay back all of their time loss payments. The injured worker is also assessed a 50% penalty. The injured worker is literally put into a place of financial ruin. And most of that, and by the way, all of that happens before they're even able to tell their side of the story or to intervene with their doctor to ask questions about, is this proper, is this right? They have no opportunity to be heard at a reasonable time and place before the department's order issues. Note that the Supreme Court of the United States, in a case called Matthews, decided that the essence of due process is the right to be heard at a reasonable time and place. But under our L&I system, what we're allowing is defense attorneys to go in and badger doctors, to coerce, and to extract statements that the doctors often tell us later that they wish they'd never given. that they regret. And the department shuts off the injured workers' benefits, and the majority of injured workers, I would say, will immediately consider forfeiting everything just to reverse the order. They'll give up their entire claim, they'll give up their right to surgery, they'll give up their right to be fixed, they'll give up the right to be retrained, they'll give up everything because they don't want to be prosecuted for an offense that could even send them to jail. If they first lose the material misrepresentation case in front of the Department of Labor and Industries, they're that much closer to being prosecuted for a crime and sent to prison, taken from their family, their children removed from their custody. The amount of pressures are immense. The legislative solve, of course, is very simple. We simply need to pass legislation that says that at any stage in an L&I case where a defense-interested attorney wants to go in and ask questions, or anyone working for the defense wants to go in and ask questions to the treating physician in an effort to obtain any kind of an opinion that says the injured worker is faking or is misrepresenting their case materially. Whenever that is the intent of the questions being asked in person, the injured worker has to be given an opportunity to be present and has to be given an opportunity to be represented. Nothing else will do. Please join me in supporting this legislative priority. Thank you.